Good morning, ladies and gentlemen. Welcome to another one of Greens List's celebrated sessions on current legal issues. This one is a particularly important issue to all litigation lawyers and has become even more significant by reason of recent statutory changes relating to the proper conduct of the issue, and that is, of course, pleading. Abe Lincoln was, before his celebrated and short-lived political career, was a very good trial lawyer in Illinois. And he said of pleading, "In law it is good policy never to plead what you need not, lest you oblige yourself to prove what you cannot." And that just about says it all, from my experience of 35 years at the bar in terms of pleading, whether it be in the Supreme Court, Federal Court, or in the County Court and lesser courts of pleading. It's the fundamental rule when you're pleading material facts, and that's what it's all about, is to plead only those facts that are material and that are necessary to plead for the purpose of proving your case, and thereafter calling evidence to prove your case. Don't plead in a prolix or complex way, and don't plead facts or issues that you don't need to in terms of proof. Otherwise you can get yourself into very serious trouble, as Abe Lincoln observed. This morning, the rules of pleading in a much more sophisticated way will be explained by two very well-reputed juniors, not only on our list but at the bar. The first is Elizabeth Bennett, and the second is Nick DeYoung, both, of course, whom are on our list and are leading practitioners as juniors in the field of pleading claims in courts of pleading. Elizabeth will be taking the issue of the practicalities of pleading in terms of overarching obligations under the new CPD, and Nick DeYoung will be expanding that in terms of what sort of requirements the Civil Procedure Act requires of people in terms of demonstrating compliance with overarching obligations. Personally, I don't think much change has occurred. I think it's all a question of terminology introduced by law reformers who, for some reason, have taken on that concept as a new concept in pleading. Nothing has really changed, in my opinion, since I commenced at the bar. The pleading rules are essentially still the same. They're still terribly important for the conduct of proper litigation. And the new Civil Procedure Act provisions relating to overarching obligations are no more, in my view, than a refinement of the obligations that have always been around, at least since I came to the bar in 1976. However, Nick and Elizabeth will no doubt have their own views on that. Elizabeth was admitted to practice on the 26th of April 2005, so she's been at the bar for 7 years, which is really a perfect sort of time to have developed a barristerial practice in a practical and operational way. She signed the bar roll subsequently, but prior to that time she'd had extensive experience at Arthur Allens Robinson, and subsequently as associate to Justice Neve of the Court of Appeal, before whom I appeared last week, who is, and also lectured me in property at Melbourne University many years ago, and would have been, no doubt, an excellent mentor for Elizabeth in her career as a barrister. She's been in a number of celebrated cases, including as junior to Debbie Mortimer in one of the major offshore processing cases recently. She was in Challenger listed investments against the State Revenue Office as junior to John Devane, and she was counsel assisting the independent review panel for the implementation of gambling reform in Victoria, chaired by Ron Merkel. So she's, in her short career, she's had a very good base for demonstrating her talents before you today, and I'll hand you over now to Elizabeth to do that. Thank you.
Thanks everyone, and thanks for coming bright and early this morning for pleadings, which is well worth getting out of bed for. It's just to start off, I tend to chime in and agree with Tony. I don't think the Civil Procedure Act has actually substantially changed things, but what it has done, and what we'll touch on a bit, it has provided a bit more clarity and line of sight when the court wants to be upset about pleadings having been done incorrectly, and it provides a very clear line between your breach of these obligations that was probably always there, but what the Act has done is drawn a very clear line to the effect of that breach for you, and quite often it will be costs. And you'll see quite often now letters are coming from solicitors saying, I draw your attention to Section 28 of the Civil Procedure Act, and I intend to make an application for costs on the basis of your breach of your overarching obligations. And you'll see in judgments, and we'll go through some of those judgments this morning, that's what the judges are doing as well. You get the sense that in the past there might have been this sense of there was something a bit inappropriate here, and people would sometimes make the submission that that should sound in some adverse order, but now in actually awarding costs or determining interlocutory disputes, specific reference is being had to those overarching obligations, and it's providing quite a firm cornerstone, if you like, for the courts to be mad at you for breaching these obligations. So it hasn't had, I think, it hasn't changed. If you were pleading well 10 years ago, you should still be pleading the same way today. But you might find if you're pleading badly that there's a different effect now, and the way that you'll be dealt with is slightly different. But coming back to pleadings themselves, I provided a paper, and I'm going to follow the form of that paper. My purpose today is to really talk about this concept of when you've got a proper basis. So Nick is going to talk a bit more about some of the formal aspects of pleading, but this is really the substantive element of things. We all know in a broad sense what pleadings are, and we know that they form the foundation of our case or our defence. We know that they're the boundaries within which we will fight the battle. And as an interesting aside, I, in preparing for this morning, did a bit of digging around into the history of pleadings, and it turns out that they were initially oral for a number of centuries, from the 12th century onwards. And they're actually fleshed out in oral discussions with the judge, who would say, well, what do you mean by that, and what facts do you need? And they would actually have this discussion to work out the pleadings. It almost actually reminds me of the first directions here in the federal court these days, where you're often cross-examined about your claim. There's almost a sense we're moving back to that form of things. We all know the general principles of pleadings. We know that we've got to plead material facts upon which we rely for a claim or defence. We know not to plead evidence. Each allegation is taken to be admitted unless it's specifically denied, either by express terms in the defence or by implication. Although again, I note the federal court has departed from that slightly. I am focusing this morning on the Supreme Court, but we'll mention differences where they arise. And finally, we know that any matter that might take somebody by surprise or needs to be the subject of evidence needs to be pleaded. If it's a material fact, it's got to be pleaded, and if the other side is going to be prejudiced by an omission and you're going to raise it at trial, you need to bring it up in your pleadings. So within that framework and that very obvious background, it's been observed that litigants nonetheless really do attempt to keep their options open for as long as humanly possible. And it is an instinct we all understand, because nobody wants to be the one to say, we can't run that, or you never want to read those words in a judgment that say, there might be some merit in this argument, unfortunately it wasn't pleaded that way. I mean, you never want to see those words, and so people keep things very broad in both their claim and defence. And the other reason is, of course, we all know the evidence comes out in trial sometimes bears very little resemblance to what it was believed to look like at the time the pleadings were being drawn. So in that context, you have this issue where parties understandably will try and keep things broad. It's not necessarily the best thing to do. It is a fear-based approach. If you're careful, you are better off with a succinct pleading and letting go of the poor claims and just having the confidence to run the case that's going to work. But the fact is that most parties will try and keep things broad. So the Civil Procedure Act really was an attempt to focus people on narrowing your claims, getting the real issues in dispute, forcing people to talk to each other about things, and to bring into focus some of these overarching obligations. And so Section 7, 8 and 9 of the Civil Procedure Act tell us that we need to abide by an overarching purpose that includes the facilitation of a just, efficient, timely and cost-effective resolution of the real issues in dispute. So that's the real point of things. And the court will exercise its powers consistently with those principles, in particular in pleading disputes. Section 18 includes an overarching obligation requirement for a proper basis, and then in Section 42 we have the proper basis certificate requirements, which also tells us a bit about what is intended to be included. So the overarching obligation in Section 18 will be very familiar to people. You must not make a claim in a proceeding that is frivolous, vexation, and abusive process, and I think the kicker is, really, does not on the factual and legal material available to the person at the time of making the claim or responding to the claim as the case requires have a proper basis. And it sounds very, very simple, but what do they mean? Because it's not very hard to avoid frivolous, vexatious and abusive processes. The question is, when have you got enough? When your client is swearing black and blue that X, Y, Z is the case, can you just plead it? Is that enough? Are we done? They tell you that they've got a caveatable interest, for example, or that something happened which is entirely contrary to evidence. And can you simply take the instruction? At what point are you going to be heading into difficult waters in respect of that overarching obligation when you're pleading? And we all have difficult clients who believe their case, who believe it beyond reason, and when faced with almost incontrovertible evidence to the contrary of their position, we can find ourselves in very difficult situations, and that's where this set of obligations kicks in. And I'm going to go through a couple of cases where I suspect that's exactly what happened, reading between the lines, where I think you might have had clients who were very interested in one outcome and who had a very strong view about their rights. And that put the lawyers in a very difficult situation, I think. And it certainly upset the court when things came out in the wash. So it's the legal and evidentiary material available. It's at the time that the thing is going on. So at the time that you're putting your pleading in and at the time the matter's been heard. And I'll argue, I think there is a slight difference between the two. I think that you need to be, at the time that you're putting a plea in, if it is urgent and there is going to be an element of grey to the extent to which you can accept instruction at the beginning, and perhaps you might, as evidence comes to light, things might clarify. And if by the time you come to trial the situation has changed, it's going to be no defence to say that it was reasonable at the time you drew it. It is a continuing obligation. You're not going to be able to say, but I thought bona fide at the time I drew it and signed the proper basis certificate that it was all okay. The court will say to you, well, you must have known from the time that this smoking gun email came to light that this was not tenable. You really need to have, at that point, you stopped having a proper basis. It's the evidence that's available that the court will look at the time that you're proceeding in the court. And I've set out at the bottom of page 3 and the start of page 4, section 28, which in my view really makes good that proposition that what you've got here is a dotted line to costs. So, and that's probably one of the shifts that's occurred by the CPA, is it's a much clearer line. And so they make clear in particular that a court may take into account any contravention of the overarching obligations in determining the costs to be So I think that's quite, and you'll see some of the in some of the cases they do refer specifically to that provision. So just to quickly run through a couple of recent cases that deal with this, and no doubt if somebody in the room was involved in these cases, they'll tell me why it was actually a bit more complicated in the way I'm presenting it. And no doubt they are. It's not my purpose today to give you an in-depth analysis of these cases as cases, more about the illustration of these points. And Sunland is a very interesting case, and it is factually quite complicated, and I've tried to distill it down to the necessary elements for the illustration of this point. You'll all be unsurprised to learn that a few years ago in Dubai, there was a lively trade in property speculation. Not sure if there still is. I'm not sure if the GFC has cooled that off at all, but it got to the stage where even the right to negotiate in respect of a piece of land was a very valuable asset. And I understand that the government in Dubai began to step in because development wasn't actually happening. It was more valuable just to hold the land and sell off constituent elements of your rights over time. So it was within that context that a dispute arose because what I will call the Sunland parties, and again there was a fairly complicated corporate structure that I don't think really matters, included a couple of individuals and a couple of their companies, negotiated with a company called Prudentia, and again there were a few companies and individuals involved, for the rights to negotiate in respect of Plot D17 in Dubai. That's the background. Sunland made claims that representations made by Prudentia were misleading, deceptive. I think there was a tortious claim in there as well. It was Section 52 of the Trade Practices Act as it then was, and the Fair Trading Act. And there was a claim for deceit. They failed about as comprehensively as you could fail in the proceedings. And following that failure, there was a costs fight in which the appropriateness of the proper basis was considered by the court squarely, and in the context of Section 28 and the context of Section 18 of the CPA. And I've actually set out in paragraph 13, I've just paraphrased what the court actually said about in highlighting these things. So the court actually went through the overarching obligations in those terms and said the overarching obligations cast upon parties and legal practitioners representing or acting on behalf of a party and should not, on the factual and legal material available to the person at the time of making the claim or responding to the claim, have a proper basis, and of course, or should have a proper basis. So that obligation has been highlighted very specifically by the court in the course of considering its costs application. And again, the narrowing of the obligations in dispute was the other one that was really focused on by the court, because it seems again that there was a fairly broad set of claims and facts that were being thrown into the mix in the course of this case. Interestingly, the court said in this case that it was the fact that they commenced or continued in willful disregard of known facts or clearly established law in circumstance where Sunland, properly advised, should have known that it had no chance of success, and where in all the circumstances the proceedings must have been presumed to be commenced for a collateral or ulterior purpose. So it's, and you'll note there that the focus on commenced or continued, it's either one. And the interesting thing about this case when we talk about willful disregard of known facts is that the court really focused in on a particular email that it said completely destroyed the plausibility of the plaintiff's case. The plaintiff said they believed they had a binding agreement with Prudentia at a particular time, and there was an email after that time that said between the parties, the senior members of the company that were the plaintiff, effectively saying, I hope we get a binding agreement. And it wasn't quite in those terms. It was things like, we need to take steps to put our foot on this deal. We can't let this get away from us. They clearly knew, on a fair read of this email, that this deal was not yet done. Now, again, we'll all be familiar with the situation where your clients say, I know it reads that way a year later, but really what I meant when I said put my foot on it was, get a formal contract signed. But I absolutely believe that we had a binding agreement the whole time. I can see how you could have clients come to you and say, even though that email seems incredibly damning, it's still the case that this case can be maintained. And that could work, except that under cross-examination in the course of the trial, these people who must have given instructions that the email meant something other than what it appeared to mean on its face, really fell apart, it appears. And that's what I find makes this case so interesting, because the court takes into account how these people performed and what the plausibility, and basically decided, well, you were being dishonest in the course of giving your evidence, and that's not an uncommon finding in cases, but took it one step further and said, so this whole thing from the beginning, you've known that there was no proper basis, and so you've improperly brought this case. And that is quite interesting. I mean, you often find judges disbelieving witnesses, but not drawing this inference from it. So I found that quite an interesting fact, and I think it comes back to this, the existence of the email, that they must have explained away. So there was this very strong evidence against what they were saying, and then it turned out that what they were saying was not in fact true. And so the court was unimpressed by that. And you'll see at paragraph 15, I've just extracted a little bit of what the court said about that and noted that you could have been expected in the course of questioning in conference before trial to have brought out these deficiencies and inconsistencies and had them be substantially discovered. Now, and they say it's simply not plausible that Sunland senior officers, whose evidence was relied upon as absolutely critical evidence in the conduct of its case, could have thought that there was any representation upon which Sunland relied as the foundation of its case, given the inability to state, either in general or specific terms, the nature and content of the representation or representations alleged as the basis of its case. So it's pretty startlingly clear finding from the court. And so it was found that it cannot be accepted that Sunland had any basis for believing that it could establish any of these critical elements of its case. So there's a very significant slap there, and indemnity costs got ordered against the company. Now, the solicitors weren't brought into the gun in the way they were in some other cases that I'll discuss in a moment, that Nick will discuss. And I can only speculate really that the issue here was that it was the senior officers in the company who maintained this position. And there's a sense that they should have been beaten up a bit more in conference to bring out the issues, and that comes out for me in that part that I've extracted at paragraph 16. But it really was the company itself that suffered here. So there's that issue for our clients, that this is a question obviously of our obligations, but even just looking at the client's own best interests, they need to be sure about their facts, and they need to be aware that this is the kind of line that can be applied. And there are cases, a lot of cases, where people fail, they were found to have not been honest. It doesn't necessarily end this way, but I think, as I said, this case was in a particular category because there was overwhelming evidence and there was no good explanation given as to why that overwhelming evidence shouldn't be accepted. So it was just taken that it was always a bit not quite right. So it really demonstrates the need to properly and carefully consider the basis of facts that you're considering. Pearl Lingerie is another case from this year that I've summarised at page 7. And just quickly, it's an interesting case. There were two caveats were lodged over a piece of land. The caveat was said to be enlivened by a joint venture agreement between the parties. The problem was that no one pleaded and no one even seemed to think that the joint venture agreement included a term that gave rise to a right to an interest in land. So while it was it was set out on the basis, and it's not a pleading case per se because it is a caveat decision, so but it's still relevant to this concept of a proper basis because it was really about the proper basis for the caveat. So there was a joint venture agreement, but that agreement didn't include any idea that there was a right to an interest in land. And worse than that, a related party had earlier lodged a caveat over the same land, which had been removed, and the judge at the time of removing that caveat had said you had better not lodge another one unless you have a really good basis for it. So in that situation, this case came to court, and it seems to have been a very quick decision to remove the caveats. What exercised the judge was who to order costs against and for how much. And interestingly, it was conceded that there should be indemnity costs, and which is I've never seen that concession be made before. But the court said, well, but shouldn't those costs be against the solicitors? And I can only imagine what happened in court when that suggestion was made. And the fact is, the court was satisfied that the caveat was drawn by solicitors, that they did so on instructions, and perhaps it accepts, I think, that the caveat was drawn by the solicitors under instructions, and probably, again, the sense I have is that it probably wasn't defective at the time it was drawn. It may not have been entirely defective at the time it was drawn, but certainly by the time it was being defended in court, they should have had the time to have read the materials, and it was found to be the case that the solicitors had not properly read all of the materials that the caveat was based upon, and hadn't made proper inquiry about what the basis was for this caveat, and hadn't properly themselves personally considered the basis for the caveat. It was there for an ulterior purpose to do with preventing settlement of the sale of the land for ulterior purpose. So you'll see I've extracted at 24. During the course of oral submissions and discussions with the defendant's solicitor, it became clear the solicitors did not have possession of the documents alleged to support the basis of either caveat, which is a pretty chilling thing to read in a judgment, I think, and that really got the ire of the court going. So, and you'll note, again, I've emphasised in that paragraph that's extracted, opinion is not good enough in the sense of you think you've got this idea, you've got to have a basis, there's got to be, you've got to have read the documents, and the documents have to be capable of sustaining it. A joint venture agreement was not at law capable of creating the interest in land absent a specific clause. It doesn't do that automatically. The mere fact of a joint venture agreement that may operate on a piece of land doesn't necessarily give an interest in that land. So there was no legal basis, and then worse than that, there was probably no factual basis either. And so the failure of the solicitors to take the time to inquire into those things resulted in an indemnity costs order against the solicitors themselves. So it's a helpful case for demonstrating what we need to do about proper basis. The instructions aren't enough. We need to examine the documents. We need to ask the questions, and that really comes out in Sunland. It's not enough just to have an assurance. You've got to ask the questions yourselves. You've got to test your clients. And so it's not... And Nick will talk now about the formal requirements, about the need to be pedantic and the need to be careful. And the same can be said for the facts. You've got to be careful. We've got to be careful. And so, as I said, that I think is the take-home message: is these documents need to be done with due consideration of these issues and their potential consequences for you and for the client, and that's really what the Civil Procedure Act has done and brings home to us, I think. So I'll leave it there. I think.
Thank you very much.
Thank you.
I think a hand to Elizabeth for elucidating in very simple terms the effect of the CPA. Can I say one thing, harking back to what I said earlier in opening the matter, in that second case concerning the caveat that Elizabeth referred to, two things arise in my mind. The first is, and it's said by Elizabeth in paragraph 27, the case itself did not refer to the CPA specifically. That's precisely the sort of result that has been occurring for 30, 35 years to my knowledge, irrespective of the CPA provisions or otherwise. If you lodge a caveat and you do so carelessly or without proper regard to the true basis of the caveat, it will be removed and you will pay costs, and I have known indemnity costs to be awarded in those circumstances many years ago when I was a junior at the bar in the practice court. I agree with Elizabeth, I've never known for an actual concession to be made as to the correctness of indemnity costs, but that gives rise to the separate question, always putting aside the issue of pleading and truth in pleading, always be careful when you're lodging a caveat to ensure that your alleged constructive/resulting trust does have a proper basis, because that is the that is the rationale or the excuse that's very frequently used, as you've known, for lodging a caveat, and in many cases there's absolutely not a scintilla of evidence to suggest that there is a constructive or resulting or other form of trust such as to justify the caveat. So I can readily see how that occurred in the second case referred to by Elizabeth. As to that the Sunland case, that was a Civil Procedure Act issue, and I just thought I'd alert. I noticed that Nick, who I'll be introducing after our coffee break, has had experience in I think an anterior aspect of the Fortescue Metals case. A reading of the recent High Court decision in that case would reveal that it too involved a real pleading issue. Indeed, Mr Justice Haynes' judgment is quite critical of counsel for the ASIC, for the way, that senior counsel in particular, for the way that the pleading in that case didn't properly characterise or describe exactly what representation was being relied upon. You may be aware that what was being sued, that was that Mr Forrest had been less than open and honest in the way he had represented an alleged, as it was found, I think, to be found to be a contract with the Chinese metals purchaser or the government. In fact, he was upheld, of course, in the High Court, and there is discussion there about the nature of a pleading in a misleading, deceptive conduct case, which is well worth consideration as the most recent statement on the point by the highest court in the land.